All right, let's call the meeting to order. Y'all ready? That's right. I'm going to call on you next. All right. Good evening, everyone. For those of you who are watching on our video that we're recording tonight, my name is Matt Green. I'm president of the Brevard Hand Alex Howard Federalist Society chapter here in Mobile. Tonight we will be hosting Alabama Attorney General Stephen Marshall. I'll introduce him shortly, but we're glad he came down. And it always seems like when we're having a Federalist Society, there's either a tropical event or an ice storm, because we've had several. But thank you for coming tonight. The Federalist Society is a nonpartisan, conservative and libertarian organization dedicated to freedom, federalism, and judicial restraint. We seek to educate the legal community through our programs and publications about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. The Federalist Society is founded on the principles of that the state exists to preserve freedom, that the separation of governmental powers is essential to our Constitution, and that is emphatically the province and duty of the judiciary to say what the law is, not what it should be. We seek to promote an awareness of these principles and to further their application through the activities that we host generally on a monthly basis. Tonight we're proud to host Attorney General Steve Marshall from the state of Alabama. Briefly, Steve became the 48th Attorney General on February 10th, 2017 here in the state of Alabama. Can you hear me okay? Okay. He's actually a native of Atmore, but I did not know this tonight. He actually lived in Mobile for a period of time. He served as Marshall County DA for about 16 years, about 2001 to 2017. When he was sworn in, he was 36 when you were sworn in. At the time, you were the second youngest district attorney in the state of Alabama. He has a host of awards and things that he's really accomplished. He helped start the Marshall County Computer Forensics Lab, and he was instrumental in the Marshall County Crystal Meth Task Force. So he's also chairman of the Alabama Criminal Justice Information System and is a member of the Alabama Sentencing Commission. He and his wife Bridget have one daughter, Faith. They are members of Life Point Church in Albertville. Tonight, General Marshall will be speaking on the evolving role of attorneys general. And it is an incredible time to be a constitutionalist, as we talked about earlier, and as your role as Attorney General in enforcing the law and applying the principles that we've talked about here tonight. So please join me in welcoming our Attorney General, Stephen Marshall. Thank you very much.
Just so y'all know that I recognize where I am. I am an Atmore guy, but my dad ran Brandon Sporting Goods Store back in the late 1960s. For those of you who remember that, I was sharing earlier that I vividly remember Camille coming through and playing around in the basement. For all the one that was there, maybe that's a foretelling of what folks were doing over in Houston. Jack Tillman was my boyhood hero as a boxer. We traveled all over the Southeast watching Jack fight. And I vividly remember Mardi Gras. And so it's been neat to be able to come back. Actually clerked 2 summers after my first year in law school here in Mobile. I had a great experience. And it's been really neat to be able to see the growth of Mobile over the last several years, and I commend you for that. So it feels a little like home being here, and grateful for the fact that y'all have taken a little bit out of your time to be able to talk to me a little bit tonight. I do feel a little bit like that story that Billy Graham talked about, the new preacher that came into town and needed to be able to mail a letter, didn't know where the post office was, and so he drives into town, sees a young boy standing on the corner, and he asks him, young man, I'm new here, preach at the church across the street. Can you tell me where the post office is? He says, sure, go up about 2 blocks, take a left, be down there about a mile on the right. He said, young man, thank you for those directions. And in fact, if you'll come to my church tomorrow, I will tell you how to get to heaven. Young boy looked at him and said, sir, I don't think I'll be there. If you can't tell me how to get to the post office, you sure can't tell me how to get to heaven. So bear with me. I realize new kid in town. And you heard a little bit about my background. And frankly, the last 16 plus years of my life have been in that criminal justice sphere. And so really comfortable, like I was this morning, talking to federal and state law enforcement officers, federal and state prosecutors at a meeting they were having over in Perdido. Really have dealt with that criminal justice lane for quite some time, because that was my responsibility as the chief law enforcement officer in Marshall County, was dealing with issues of public safety.
But the opportunity to be the Attorney General of Alabama is a very different role, and includes obviously some of that criminal justice sphere. But for me, not only was that challenge initially figuring out who it was that worked at the office, and I will tell you there's 162 folks that work for you at the Attorney General's office that I'm very proud of. There's some really good lawyers, and that's been one of the things for me in working over the last several months, is getting to know them and understanding the caliber of work that they do. But it was even for me trying to figure out not only what our divisions were, but where the bathroom was. So there's a little bit of that learning curve. But the bigger curve for me was really developing a vision for the office. What is it that I saw as the role of the Attorney General in Alabama, and to sort of figure out how it is that I could articulate that vision to people around this state about what it is I wanted to do and what I wanted to accomplish. It really caused me to kind of step back in time a little bit and sort of figure out what is the role of Attorney General generally. And so to do that, I had to look back at a little bit of history and try to look at some of my other colleagues around the country to see what they've done, what we've been involved with, and what it is that I've seen from them and those that preceded me in Alabama to help me learn about what is the true function and role of Attorney General. So what I want to do tonight is spend a little bit of time talking to you about kind of what I've learned and what I've seen. And I will tell you kind of interestingly, the very first thing I did for you as Attorney General of Alabama was sue the state of California. That's when I knew I wanted this job. We had to sue them over regulations that they entered involving the importation of domestic eggs, and we joined in various lawsuits against them. But it really was a very unique and very different thing. And so probably one of the second things I did was to sign, along with several of my colleagues, supporting the Trump administration's ban on individuals coming from certain terrorist countries. I mean, that was very different than the world that I came from as a district attorney, but yet fit neatly into what I believe to be the role that I now have as Attorney General. So here's what I sort of thought I would do for us today, is really sort of explore with you why in the world does it matter to you, what is the role and the function of the Attorney General going forward in the state and nationally. And I will share with you that President Woodrow Wilson once said this: the cardinal question of our constitutional system is the relationship that should exist between the federal government and the state. As Attorney General, one of the things that I see is that tension between the federal and state government requires working on issues that, for me, raise concerns not necessarily of a local issue, but also transcends our state borders. So what I wanted to be able to do today, I guess, a little bit is talk about understanding that premise, really focus on three things, one of which is kind of first talk to you a little bit about the historical nature of this role that I now have as your 48th Attorney General. Then we'll talk a little bit about what has occurred in the more recent past that we've seen Attorney Generals really sort of escape what was a fairly narrow focus that existed historically. And then third, let me share with you about the direction I think that you'll see from me going forward that I think is consistent with many of the principles that this group holds dear. All right, first question. Anybody know where the first Attorney General was in this country? All right, seeing none. 1643. The wonderful Commonwealth of Virginia during colonial times, that was the first Attorney General that was ever appointed. Had a very singular role. That role was simply to advise victims who were responsible for prosecuting their own cases. That eventually sort of enlarged into the early 1700s. That Virginia actually appointed an Attorney General that really became a de facto statewide AG. That the only role and the only function of the Attorney General was simply to be able to prosecute cases in the criminal courts of Virginia. And really that role of the Attorney General as the top cop, the chief law enforcement officer of the state, has really persisted for centuries. And if you think about Alabama, we just simply need to say Charlie Graddick or Bill Baxley, right? I mean, they were prosecuting murderers, rapists. They were out there suing the KKK and those that were polluters. I mean, they were ready to try cases all over the state of Alabama, and that was the function and the role that they saw. But generally, the Attorney General, not only for Alabama, but during that time, really limited their role to what was occurring within state boundaries. And they did not see themselves as somebody that would impact or affect issues of national importance. And that began to change in the early 1990s. And one of the things that you'll probably be most familiar with is the tobacco litigation that went on. And I would sort of call sort of this transition of one from just a top cop to one where AGs began to see that they could engage in regulation by litigation. If y'all recall how that litigation started, it was a banding together of multiple AGs across the country to sue the tobacco industry. And that suit was really about not only the nature in which that business was conducted, both from the marketing and sale of tobacco products, but also it related to a recovery of damages for what states were spending for those that were suffering medical consequences of cigarette smoking. And ultimately, in the 1998, I believe it was, there began to be that master settlement agreement, which interestingly, by the way, from an Alabama historian side, Bill Pryor is the only AG that didn't sign it. Actually, it was signed by the governor of Alabama. But it was all 50 states came together with the tobacco industry, and they really did two things through that agreement. One of which was to get the tobacco industry to reform their business practices, for example, not marketing to youth, and also to be able to pay ongoing damages based upon sales of that product in those respective states. And so for the first time, what you saw from attorney generals is get outside of that criminal justice lane and instead greatly expand their role to affirm sort of what became a quasi-legislative function through that settlement, because what they end up doing is, number one, regulating an industry. It's through that master settlement agreement, they, not Congress, began to regulate tobacco, and they also imposed a tax that was outside of something that was imposed by Congress. Now, that's probably the most famous example, but we saw other examples in the last several years of a very similar nature. For example, New York and northeastern states filed a lawsuit against the 5 largest public utilities, requiring them to reduce carbon dioxide emissions. And they filed that lawsuit, although those companies were not based in those particular states. We had California sue the largest car maker to compel them to reduce emissions to stop global warming. And then we saw lots of other examples of smaller cases where AGs came together to try to regulate an industry through the litigation that they engaged in across this country. In fact, we saw some AGs go so far as not just necessarily trying to regulate by litigation. They began to try to regulate by filing litigation to compel EPA and other agencies to engage in a regulatory process. The most famous case was from 2007. We really know it because it dealt with this issue of standing, but that was Massachusetts versus EPA, where a group of AGs successfully sued the EPA to compel that agency to adopt rules that regulate carbon dioxide as a pollutant under the Clean Air Act. They did so by arguing that the states, unlike environmental groups or others, had a special standing to litigate over issues of public importance, and the Supreme Court agreed. Controversial decision at the time, and one that many conservative AGs didn't agree with, but yet what we've seen is that those conservative AGs, including ones in Alabama, basically adopted that strategy, but for a different purpose. Is that by having standing to be able to go forward, rather than trying to regulate by litigation, they engage in something known as deregulation by litigation. Primarily conservative AGs use that same strategy and infrastructure that was developed previously by others to be able to put a check on the federal government's ability to regulate. The driving force behind those lawsuits, which is the federal government, especially the executive branch, was exceeding what the law authorized. Now, the best example that I can show you of recent times is when 26 states came together, all Republican AGs against President Obama, dealing with an executive immigration order that would have provided work authorizations and residency documents to certain illegal immigrants, DACA. You've heard that being discussed out there. No private party generally would have had standing to sue in those circumstances because it harmed the country as a whole and not a particular person. But conservative AGs use the precedents and legal strategies developed for regulation by litigation to sue in that circumstance, ultimately forcing the federal government to withdraw that executive order when the Supreme Court agreed that that order exceeded congressional authority. All right, a little bit of history. We kind of see that over time we've moved outside of that criminal justice sphere into one where AGs, both conservative and liberal alike, have banded together to try to deal with issues of national importance. Let me tell you what I think that we've seen go on here recently. The first of which is a continuation of that regulation by litigation strategy. About a year, I guess a little over a year ago, a group of AGs held a press conference with Al Gore. That's where you're supposed to boo. But Al Gore came together with them basically to challenge what many were doing in the world of proclaiming, both from energy think tanks and those in the industry, about denying that climate change took place. Those folks called themselves the AGs United for Clean Power. They compared their action and their investigation in that case very similar to what happened in the 1990s against tobacco companies. In other words, their express intent was to use litigation to compel that industry to change the public discourse about climate change, the same way that we did in the 1990s to compel how the tobacco industry marketed their product. Their goal ultimately was to go around Congress and to create a nationwide legal regimen for climate change disclosures. But there was a difference between the tobacco litigation and what took place there, and that is that the industry pushed back. Exxon, for example, was served with a subpoena, and they filed a lawsuit challenging it based on First Amendment grounds. We also saw pushback from Congress, who investigated those OG's investigation to see whether or not it was politically motivated or whether or not they had standing to pursue it. Second, not only are we going to see that continue, we're also, I think, going to try to find AGs like me that will try to block federal executive action that otherwise violates the principles of federalism. That's what we did during the Obama administration, where we saw multiple lawsuits filed, particularly against EPA, which, as we all know in this room, took a very aggressive view of their role and regulatory authority. But also we saw it when the Department of Labor was sued to stop overtime rules that were coming into place. And then there was also that Department of Education policy about one size fits all for boys and going into girls' bathrooms in K through 12 schools. Both of those were successful in being stopped as they went forward. Since the Trump administration has come aboard, liberal AGs have taken up the mantle of federalism to start filing similar lawsuits, the most prominent of which is the multi-state lawsuit against President Trump's order limiting immigration from certain high-risk countries. And what I believe is, as long as Congress is gridlocked, the president, no matter who it is, will try to accomplish policy objectives by executive order, which will leave those policies open to a legal challenge. The third thing I think that we've continued to see is a resurgence of the kind of litigations like we saw in Massachusetts versus EPA, where state AGs are suing the federal government to force it to regulate. For example, New York's AG is currently leading a multi-state effort suing the Trump administration for delaying efficiency standards for a host of appliances like refrigerators or commercial boilers. That same group has sued the administration now that it's revoked an Obama-era rule that greatly expanded the scope of the EPA's authority under the Clean Water Act. That was the WOTUS rule that they recently rescinded. Philosophically, I think that everybody in this room agrees that this litigation by liberal AGs has nothing to do with federalism, because nothing about those two rules I talked about or others like them prevents the states like New York from doing anything. Nothing from the federal government is proposing to do would stop New York from regulating appliances or how water is dealt with. And as in Massachusetts versus EPA, these AGs are trying to compel regulation at the federal level so that other states cannot compete with them by adopting more friendly business policies in those respective areas. I think you'll continue to see those trends going forward. And with that background, what is it that I expect that you'll see from me? First of which, and I think this is a major priority, is that we have to consolidate and protect those conservative wins that occurred during the Obama years. For example, Justice Scalia's last official act was to vote in a case filed by state AGs to stay a massive rule under the Clean Power Plan, which would have imposed a version of cap and trade on the nation's energy markets to combat global warming. The Trump EPA has already announced that it plans to change that rule. So that change and that decision will prompt the parties to switch sides. Those environmental groups that previously supported EPA in that rulemaking will now sue the Trump administration relating to them rescinding that rule. We plan to make sure that we assist with AGs of a similar ilk around this country to be able to preserve that initial victory when that challenge is made. Second, you can see us continue to combat federal overreach. I'm a Republican. You may be surprised for me to say that, considering we have a Republican president. But I think it's the essential role for AGs who care about the rule of law to make sure that we deal with federalism on a nonpartisan basis. For example, the Trump administration is not going to be able to roll back all that happened under Obama. Independent agencies and entrenched bureaucracies like the CFPB, they're not going to change their position just because Trump is president, Jeff Sessions is the attorney general. The pace at which political appointees has been appointed obviously has been incredibly slow. And what we're going to see is the administration is going to have difficulty in rolling back policies quickly. Lawsuits may remain the most effective way to achieve certain types of change. And even when we have friends in Washington, litigation and threats of litigation can be useful to call something to their attention and prompt them to do the right thing. One of the areas that the Obama administration used successfully was something called sue and settle. An environmental or other liberalist activist group would be invited to file a lawsuit. The administration would settle that suit in a manner that would allow them to make a policy change what otherwise lawfully they couldn't do. Now, I will tell you, I don't plan to use that type of litigation nefariously, because I think that many times those type of lawsuits undermine the rule of law. But yet the one thing that we can take away from that strategy is that those lawsuits can serve a useful purpose in signaling to the federal government that a policy should be changed and prompting the government to make that change. Finally, I think in this area you're going to see that we're not going to agree with President Trump on everything. Sometimes the Trump administration will do something that overreaches into the sphere of the states, and when it does, we'll join litigation against the new administration just like we would have done against Hillary Clinton. The best example I can show you is that we recently joined Texas and 10 other states to challenge the failure of the Trump administration, despite their promises to do so, to roll back certain orders of the Department of Homeland Security in the area of immigration. For me, the proper relationship between the states and the federal government is about principle and not partisanship. Our system's division of power between the states and the federal government preserves the integrity, the dignity, and the sovereignty of the states. And as a byproduct of denying any one government complete power, the Constitution's federalism also protects us from government overreach. So making sure the federal government operates within its constitutionally defined sphere is important to me, no matter who is in charge of the federal government. And finally, we are continuing to evaluate the way that we do consumer protection litigation. As AG, one of my greatest responsibilities is protecting the state's consumers from abusive business practices. Many times this means that we join other states in litigation. The best example of that has occurred right here relating to the BP spill litigation. BP hurt this state. We sued as a state. We recovered damages. And when a business hurts Alabama or its consumers, then we need to make sure that we enforce state law. But my office should not be a part of efforts by other AGs to use civil litigation to regulate industries or to coerce windfall settlements. Sometimes that may mean that my office sits out of litigation that other states initiate. For example, you've seen that right now in the world of opioids, where many states have sued, both Republican and Democrats alike, relating to that problem we have in this country. I'm not convinced that's the right way to go. But at a minimum, I intend to make sure that consumer protection litigation focuses on the actual interest of the consumers, and that includes their interest in the freedom to purchase goods and services at reasonable prices in an open market. Going forward, I hope to be a part of many additional initiatives on a nonpartisan and bipartisan basis. Currently, I serve as co-chair of the National Attorney General's Association Federalism Committee. Hope to lead bipartisan efforts to attract bipartisan support. For example, I think we need to unravel consent decrees between the states and the Department of Justice. Some of those consent decrees have been around for long after I've been practicing law, and they are hamstrung the way that state agencies and school boards in both red and blue states serve their residents. All right, maybe that's more than you wanted to know, a little bit about history, maybe more than you want to know about how it's evolved, but I do think it's important to know the perspective that I will bring to this role and where it is that we're going, because whether one agrees or not, we have reached a point in this country where AGs can have a significant impact on national policy by regulation and by litigation, by spurring the federal government to act, or by blocking the federal government through certain action. The end goal is not conflict for conflict's sake, but as Alexander Hamilton put it, to form a double security to the people by preventing either government from overpassing their constitutional limits by a certain rivalship. It is a remarkable opportunity for me to be able to serve as your Attorney General. I understand that in this role, I have a responsibility to the people of this state, as well as to my responsibility. I'm taking an oath under our Constitution, and that is an oath that I intend to uphold every day. Now, I've spoken a lot, and I will be glad to now answer any questions that anybody has. I can't believe there's no question. I'll answer this, just to share this with you, because I do think it matters a little bit in what we talked about, because part of what has been in the news greatly is the litigation that we filed in Birmingham relating to a bill the legislature passed in the last sessions involving certain monuments and what communities and municipalities can do with monuments. You know, my job as Attorney General is to enforce the law. I'm not there to provide my personal belief about what or shouldn't happen, but my job instead is to make sure that when a law is lawfully passed, that I'm there to enforce it. And when the mayor of Birmingham put a barrier around a monument, I felt like it was incumbent upon us as quickly as possible, partly because of the circumstances of Charlottesville, to make sure that we initiated that case so that we could tell the people of this state that a court is going to decide and that we'll allow for this to be handled in an appropriate way. And so I feel very strongly that by initiating that quickly, we made sure that there was not violence, that there was not difficulty around Lynn Park in Birmingham, and I think that's come to fruition. That's a monument that's been there since 1905, 1908, I believe. And so we'll see what a judge is going forward. Now, only lawyers in this room can really appreciate the fact that that's a case in which there's really not a dispute of fact. Everybody pretty much see that there's a wall around it. The issue in the case is very clear, is whether or not that wall constitutes either disturbing or otherwise altering that monument. And so I expect that to not only be a case that will be decided in the Circuit Court of Birmingham, but we'll also see that go up to the appellate courts to give guidance to other municipalities about where that may be going forward. The other thing that I think is somewhat timely, I mentioned to you that we joined 10 other states led by Texas, challenging the Trump administration's failure to rescind a Department of Homeland Security order on immigration. Many refer to that as the Dreamer Act. We've given the Trump administration until next week to make a decision about what they're going to do. And so it'll be interesting to see whether or not they decide to make that change. We continue to hear multiple rumblings coming out of D.C. about whether they will. The basis for that for me is not whether or not I have empathy or belief about whether those who are here under those circumstances should stay. My position is simply that's a congressional decision. That's not one that should be decided by executive order. And so we'll see where that is going forward. All right. Anything else? Yes, sir.
Are you familiar with the Gonzalez versus Rate case?
You have to share me a little bit.
Commerce Clause case, I believe the early 2000s, where two defendants were accused by the federal government of violating marijuana laws for cultivating and using their own marijuana in California. And the state of Alabama joined in an amicus brief to the Supreme Court, stating that they disagreed with California's decision to allow medicinal marijuana use, but that they, Bill Pryor was the one who signed it, saying that California has the right to make that sort of decision as a sovereign state. If the Trump administration's Department of Justice, headed by our own Jeff Sessions, who's very famously against marijuana, were to prosecute such cases in states like Colorado or Florida or California, do you think your office would take a similar tack as that of your predecessor, or do you think you might side with the Department of Justice?
I'll have to look at that issue more to make sure I understand completely what was decided in that particular case. This is a little bit of the prosecutor coming out in me in this. I have very strong feelings about marijuana. I think I share Attorney General Sessions' belief on that. Having said that, that personal belief will not overcome what I believe the rule of law requires. And so we'll look at that first and being able to decide whether or not we would join. But it's an interesting question. I can get you an answer if you want me to. I can answer for you today.
Thank you.
Right. Anybody else? Yes, sir.
Attorney General Sessions created a firestorm about a month ago with his new order on civil asset forfeiture. What did you think of this order, and where do you stand on the aggressive use thereof?
I don't think it should ever be used aggressively. I ran a drug task force as part of my role of a DA. And one of the things that I always directed those officers who work for me is we're not chasing money. If we happen to find resources of somebody who's engaged in criminal activity as a result of that, then sure, we can pursue it, but that should not be the driving force behind where we were. The other thing that was also an issue at the state level is there need to be a clear firewall between the civil asset forfeiture case and the criminal case, because what you didn't need is somebody coming in saying, I'll be glad to let him plead to this, and we'll allow you to take the money. Those two are totally separate issues. The order that Quinn's talking about was this idea of equitable sharing, which allowed for state and locals to use the federal courts in the forfeiture of assets were obtained through a state investigation. I will tell you that we saw great benefits from that at the local level. There were many resources that were gained for us to be able to fight many of the battles that we see on the criminal side as a result of what took place there. And to the extent that the Obama administration stopped it, I think that went too far. I think there are many proposals that are out there right now to make asset forfeiture fair and to be able to reform the process in a way that it makes sense. So I'm not against abolishing it, but I'm also not against all sort of taking a fresh look to see whether or not we can create greater due process, that we can ensure that we tie directly that money to criminal activity, and that we're doing asset forfeiture the right way. One of the things, I'll give you an example of one of the things that I don't agree with is that they were allowing, and there's proposals to allow, let's assume $10,000 at seized, just as an example. that a criminal defendant then could come in and ask a court to order at least 5,000 of that to be sent directly to a defense lawyer to come in and defend them. Now, I don't think that ought to be the case. Having said that, we need to make sure that due process exists and that anybody who is subject to a forfeiture action has the responsibility of the state to be able to prove that those proceeds are directly related to their criminal activity. It's a significant issue nationally, just as criminal justice reform has been as well. Any other questions? Yes, sir.
You mentioned the CFPB earlier. Is the Attorney General's office presently involved in any cases involving the CFPB?
Not directly. I spoke to a group of lenders here recently, encouraging them to provide me with information that potentially could relate to that. Because the litigation that exists, and I'll tell you that the litigation that's going to survive all of ours is the water wars between us and Georgia and Florida. In essence, that litigation is simply about the rulemaking authority of the Corps of Engineers and what they do. And so many of the fights that we've had have really been very technical fights under the Administrative Procedures Act about what can and can't be done, although it's kind of moved into and morphed into, to some extent, whether or not by executive order, the executive branch has exceeded their authority. And so CFPB is this strange animal in the nature of it's created, which doesn't allow us, I think, a great deal of activity, although one of the things that we've done is engage in many sort of issue letters from AGs where we can kind of inform Congress collectively about where we see that there's overreach. And there are horror stories out there about CFPB and what they're doing, not only to businesses with valid business practice, but basically through that administrative arm dictating how people in Alabama and across the country have to conduct their business in a way that completely exceeds what I think is their authority. So I'm hoping there are going to be other options in the future. Part of that issue may be solved by the current director deciding to run for governor of Ohio, which I would welcome him to do, and he can go back to Ohio and do what he's doing. But yet I think we have a role to make sure that they operate in a sphere that's appropriate.
The reason I ask is because Alabama's Attorney General joined with all the other states, and 5 of the largest lenders in the country were found liable for gross violations.
This is on the mortgage fraud settlement?
Mortgage fraud, and I tangentially got involved in that, and I was shocked at what was going on. And I guess my question is, wouldn't there have already been a vehicle prior to CFPB's formation where U.S. attorneys could have taken the leaders, or people in the Treasury Department or other departments of the federal government could have pursued that? Because some of these were nationwide actions that were taken by these lenders, and they ended up coughing up billions of dollars for these funds, where mainly less educated, less financially viable debtors were involved. And I'm just curious about that because I know the Alabama AG signed on with that, and Alabama got a significant amount of money from those global settlements.
Yeah, I don't know about what the federal authority would have been. There would have been Alabama authority and other state AG authority on our consumer protection statutes, because each of those violations were something that could be actionable both in state court but also joined together. I'll give you an example. Volkswagen, if y'all followed that litigation where they falsified emissions and miles per gallon records. That was one where under our consumer protection statute, we were able to deal with that fraudulent activity. And in fact, Volkswagen paid a significant sum nationally as a result of that. I don't know why that couldn't have been done in the same way with the mortgage fraud settlement outside of CFPB.
Because I'm involved in another case where the CFPB is using its CID, where they have civil investigative authority to tell a company, which is a huge weapon.
Oh, it's a huge weapon.
That they're using, but there is a federal judge in the Eastern District of Michigan right now who has directed the defendants to produce all these records. And he went up to the Sixth Circuit, and then the defendants dismissed their appeal. They're trying to work it out. So even though it may be questionable whether constitutionally they've got the authority, at least in some of this litigation I've been involved in, the states have really not been the ones who would, as you suggested, have the authority with their own clubs, maybe not as big, to go in. Does the state attorney general's office CFPB employees to do almost what is known as pre-suit discovery.
Yeah, I was going to say, we have through our consumer protection statute the ability to do pre-litigation discovery, and in fact that's going on in multiple settings. For example, because it's public, we don't usually disclose that. It's almost akin to somebody under investigation by a grand jury. You don't talk about it, but because it's been related in a press release, there's a multi-state going on right now where we're a part dealing with opioid manufacturers and distributors. And so in that context, we can request documents. We have an opportunity to interview witnesses. And so there is that same way.
Montgomery Circuit Court, is that where you?
It's not necessarily in circuit court. I mean, it's outside of any pending litigation. It is really one that we have the ability.
Issue it straight from your office?
Yes, sir. Yes, that exists.
That's a big difference from the CIDs that get tied up in federal courts.
Exactly. And again, it's one of the reasons why I spoke about examining how we do consumer litigation. I don't necessarily just need to be a plaintiff's firm, and that we're just out there willy-nilly suing folks. It needs to be something that, number one, violates the consumer protection laws, but also benefits the consumers of the state. And so in many cases, through our consumer protection statutes and through pre-litigation discovery, number one, we know where we are as well as the business does, and that we have the opportunity through a conversation figure out whether or not there's a potential problem or not.
My final question on this whole area
Yeah.
is, do you have an opinion on whether a lot of the consumer-oriented / plaintiffs firms have tried to piggyback on CFPB to let the government essentially do the work and spend the money, then they coordinate that, or do you have?
I would have no knowledge of that. You would probably know a lot better than I would. So, bless your heart, by the way. All right. Y'all, thanks for inviting me to Mobile. I appreciate the opportunity to be able to meet you. Thank you.